Good evening and good morning as well. So my name is Aurélien Orange, and together with my colleague Anna Maria Urbanova, we will have from the Quarks Foundation a day 2 match of the Inter-University Law Debate Tournament between two teams, one team representing the University of Kansas in the US and one team representing Durham University in United Kingdom. So they received the topic, and now I will give the floor to my colleague to host the match.
Thank you. Thank you very much to Professor Laurent, and also a warm welcome to our two participating teams, and also to the judges who will be, or perhaps already are, reviewing this match live on YouTube, and of course to all our viewers. First of all, it is 11 a.m. in the US, and it's almost evening for the European team from the Durham University. So I won't be keeping you much longer. I will pass you the floor for introduction shortly. Just a short reminder, this is a day 2 match, so all debates share the same theme of space governance and commercialization of outer space. Specifically, the two teams today received the topic 7 days in advance on whether or not international law should establish legally binding environmental protections to mitigate the long-term consequences of space commercialization. As always, we'll find out shortly which position will be allocated to which team. And thus, without further ado, passing the floor first to the team of University of Kansas, Ms. Taylor.
Hello, my name is Caitlin Taylor, and I am from the University of Kansas School of Law, and I'm excited for the match today.
Thank you and welcome. For the Durham University, passing the floor to Ms. Nelligan.
Hello, I'm Ailey Schnelligan, and I'm studying law in my second year at Durham University.
Thank you and welcome. For University of Kansas, Mr. Poland.
Hello, my name is Harrison Poland, and I am also in my second year of law school at the University of Kansas, and I'm excited for the competition.
Welcome. For Durham University, completing your 2-member team, Mr. Sluchenkov.
Hello, my name is Ivan Sluchenkov, and I'm a Durham University student.
Welcome. And completing the 3-member team of University of Kansas, Ms. Nelson.
Hi, I'm Israel Nelson, and I am a 3L at the University of Kansas School of Law, and I'm excited to be here.
Welcome, and once again, thank you, everyone. My colleague will share his screen shortly for the allocation of positions. As always, after the positions are assigned, you will have 5 minutes for your finalization of your preparation, and the team in favor will start with the opening statements for 4 minutes.
Yeah, I will share my screen now for the allocation. So normally you should see my screen in a few seconds. So there is a wheel with the 2 double flags with the logos of your institutions. As you can see, there is a chance to be in favor and a chance to be against for each institution. So activate now the randomizer, and we'll know which team will start, meaning the one in favor. So that will be Durham University will be in favor of the motion and will be then doing the first introduction. As a consequence, the University of Kansas will be doing the, I would say, the against position. So it means concretely Durham University will defend the position that international law should establish legally binding environmental protections to mitigate the long-term consequences of space commercialization, while the University of Kansas will be defending the position that international law should not establish legally binding environmental protection to mitigate the long-term consequences of space commercialization. So now you will have 5 minutes to review your notes, and then we'll start the match with the introduction by Durham University. And you can close the mic and camera if you wish. Here we are done with the 5 minutes, so I stop sharing my screen.
Yes, so as your time for final preparation is over, just a short reminder from my video stream, when you see a yellow card, it means you have 30 seconds left of your speaking time, and when you see a red card, it means your speaking time is up. Of course, you don't have to cut yourself short immediately, but yes. So best of luck, starting with the team in favor. You now have 4 minutes for your opening statement.
Thank you. Ladies and gentlemen, esteemed judges and fellow debaters. Imagine a future where space, once a symbol of limitless potential, becomes a junkyard of debris, toxic emissions, and unchecked exploitation, just as we've seen on the Earth. Without legally binding environmental protections, this isn't a distant possibility, it's an impending reality. Today, I stand before you to argue that as we commercialize space, we must not repeat the mistakes of the past. Instead, we must act now to safeguard the final frontier before it is too late. We need legally binding protections to protect us from the environmental impacts of space commercialization. Space activities are already causing environmental harm, yet existing international law is insufficient to prevent it. The Outer Space Treaty states in Article 9 that states must conduct activities with due regard for others and avoid harmful contamination. However, this provision is entirely too vague. It lacks enforcement mechanisms, and it doesn't directly bind private companies who are now the driving force behind space commercialization. The consequence is a rapid increase in space debris, which threatens both sustainability and safety. The European Space Agency reports over 36,000 pieces of trackable debris, with millions of smaller fragments. Without regulations, collisions will be triggered, rendering space unusable. This isn't a hypothetical. There have been collisions in 1996 and 2009 between satellites, demonstrating the growing hazard. A hazard that will only increase in risk with the more debris that we are put into the atmosphere. Beyond debris, rocket launches release black carbon pollutants that contribute directly to the global climate change crisis, yet these remain unregulated despite the Paris Agreement, limiting emissions in other industries. This poses a risk not just to the future of space exploration, but also to the future of humanity. Similar industries are already subject to binding agreements, such as the shipping industry with the MARPOL Agreement. So why is it that space should remain the only exception? Legal precedent supports international environmental responsibility. The Trail Smelter Arbitration established that no state may cause transboundary pollution. And similarly, in the Pump Mills case, the ICJ ruled that states must conduct environmental impact assessments before engaging in activities that may cause harm. These principles must now be extended to space. Some claim that enforcement can be impractical, yet we have successful international mechanisms. The Montreal Protocol, which regulates ozone-depleting substances, proves that nations can cooperate on environmental treaties when backed by compliance measures. National regulations and voluntary agreements are also insufficient, as space is a global commons, leaving governance to individual nations would only create loopholes. This would allow companies to exploit weak regulations, as we have already seen with the effects of tax havens. Space commercialization is rapidly accelerating. The number of satellites has quadrupled in the past decade alone, and thousands more are planned. Without legal protection, we risk irreversible environmental damage, repeating Earth's industrialization mistakes in a domain where consequences are permanent. Without oversight, private interests will exploit space at the expense of future generations. Space will no longer be a source of hope, but it will be one of harm. So we have a choice. We can allow space to become polluted or chaotic, or we can act now through legally binding international law. The future of space and our planet depends on this decision. And for these reasons, I strongly support this motion. Thank you.
Thank you. Thank you for your submission. We'll now hear the opening statement for the against position. University of Kansas, you have 4 minutes.
Hello, my name is Harrison Poland, and I am representing the University of Kansas. Today, I will be arguing that international law should not establish legally binding environmental protections to mitigate the long-term consequences of space commercialization. Now, the first point I would like to bring up deals with who we are as a society. Our world as we know it today has been driven by development, and with development comes an irresistible goal of efficiency and innovation. Rules and regulations governing the actions of our lives only work to stifle these considerations. As we turn to the topic of space and the development of space commercialization, our society is presented an incredible opportunity in which we should work to develop and innovate the resources space gives us as efficiently as possible in order to truly maximize the capabilities space has to offer us, such as the various natural resources that can supplant for the finite resources here on Earth. Thus, in order to truly take advantage of the extraterritorial surpluses space has to offer, the international community should focus on the development of property rights within outer space, if anything, before any binding environmental protections against space commercialization are created. Now, this idea is emphasized by laws that countries have passed regarding space exploitation, while avoiding the topic of binding environmental protections mitigating the long-term consequences of space commercialization. For example, the U.S. has passed the U.S. Commercial Space Launch Competitiveness Act of 2015, which explicitly states that a U.S. citizen involved in commercially extracting resources from an asteroid or space shall have the right to possess, own, transport, use, and sell those resources in accordance with relevant laws, including the international obligations of the United States. Luxembourg, in 2017, passed the law on the exploration and use of outer space, which establishes that outer space resources can be claimed and permits private entities to engage in approved commercial activities. Finally, Australia has allowed private companies to participate in space mining with the enactment of the Space Launches and Returns Act in 2018. Now, finally, I'd also like to bring up another point and why we should not establish legally binding environmental protections, because it would put the least developed countries at a disadvantage. Now, developed countries are the ones already in space, and developing countries are still working to create spacefarer programs. Private companies, not countries, are the main commercializers. Thus, international law will mostly affect states, as most commercial agreements private citizens can opt out of, or it doesn't apply unless the state itself makes it national law, creating a situation where if environmental protections are legally binding, developing countries not only have to work on developing a space industry, but building an environmentally friendly space industry. There is no significant consideration of the state practice of opinion juris of non-spacefaring states. While focusing on the interests of those nations already in space aligns with the principle presented in the North Sea continental shelf case, customary law does not form merely because 5 to 10 states have not overtly acted contrary to their treaty obligations. Thus, it is unlikely that many poorer states would accept the imposition of customary law created almost exclusively by wealthy Western states as they reach space first. Furthermore, this goes against Article 1 of the Outer Space Treaty, which clearly articulates that space is to be used in the interests of all countries and remain the province of all mankind. Now, regulatory burdens impact smaller enterprises, startups, and developing nations in a disproportionate manner. Increased regulation potentially increases established Western powers, reducing competitiveness throughout the world. Evidence suggests size-contingent regulations can produce significant market distortions. Regulatory implementation in this regard would damage the chance of developing countries to first develop and scale a sustainable space program, allowing independent access to outer space. And finally, developed countries are already taking action to ensure that we have environmental protections in space. This is seen with actions done by the US, Japan, and the United Kingdom. Thank you.
Thank you. This concludes the opening statements. We'll now hear the first rebuttal by Durham University for the in favor position. You have 2 minutes.
Opponents argue that regulations stifle innovation, but history proves otherwise. The Montreal Protocol supported industrial breakthroughs, and the pulp mills case showed that environmental laws and economic progress can coexist. Clear rules drive sustainable technology and not hinder it. Prioritizing property rights over regulations ignores legal precedent. The Shell Smelter arbitration confirmed that no one can claim rights while causing environmental harm. The Outer Space Treaty already mandates preventing contamination. Ownership must come with responsibility. Finally, without regulations, lesser developed nations will suffer most. The nuclear test case established that powerful nations cannot impose environmental harm on others. Without oversight, wealthy countries will dominate space, leaving pollution and debris that harm emerging space programs. Environmental regulations ensure fair access, protect future innovation, and prevent irreversible damage. If we fail to act now, we risk repeating Earth's mistakes only this time, and there is no second chance. And additionally, the Liability Convention holds states accountable for damage caused by their space object, and this principle can be expanded to enforce responsibility for environmental harms such as space debris accumulation. If states can be held liable for physical damage, why not for environmental degradation as well? Binding international laws have successfully governed other global commons like the oceans, and the same thing can be done with the space. By establishing binding regulations now, we can ensure that space will remain sustainable. Thank you.
Thank you. We'll now hear the first rebuttal for the against position. University of Kansas, you have 2 minutes.
Thank you. First, we'd like to address the stifling innovation agreement. Yes, it might encourage innovation for environmentally friendly innovation, but that's only an opportunity that developed nations have the opportunity to take advantage of. Developing or less developed nations are not at the point where they can move to making this innovation more environmentally friendly when they don't have one to begin with. When we're talking about the cases that have implications, they are only binding on the parties within those cases and not on future cases or states that were not party to the litigation. And this mitigation that we're discussing, where we're saying it's a junkyard, we actually are already working on reversing some of these things. For example, if we look at the US, they have the Federal Aviation Administration, which has posed rules for disposal of rocket bodies left in orbit. The European Space Agency has a zero debris approach and is developing technologies to remove space debris. Japan has the JAXA, has developed technologies for capturing and removing space debris. And the UK has a government-launched plan for space sustainability in 2022, including a fund for active debris removal. These countries are already taking responsibility and already taking advantage of ways to mitigate this. If we then add on these regulations to make them internationally binding, the main ones it will be affecting are the less developed countries and the ones beginning to explore into space. It is not going to affect the ones that are already there who have already explored these technologies and already looking at mitigation approaches on their own without this internationally binding agreement.
Thank you. We'll now hear the second rebuttal for the in favor position. Durham University, you have 2 minutes.
Thank you. Well, I think the argument has been made that several times that this will prevent developing nations from creating their own space programs. However, for developing nations, legally binding regulations would ensure fair access to space rather than hinder it. With the accumulation of space debris, this will prevent many developing countries from having space to launch their own satellites or rockets off into space. Moreover, without international protections, wealthier nations and private corporations can monopolize space resources and leave developing countries at a disadvantage, much like how unregulated resource extraction from the Earth led to economic inequality. And this is sort of proven by the and supported by the UN Convention on the Law of the Sea, which ensured fair access to maritime resources while preventing environmental destruction, something that a hypothetical space commercialization act could be based off. Moreover, I think one point that has been missed is the fact that largely it is corporations and not countries that are driving space commercialization in the modern era, companies such as SpaceX and the like. And it is completely unrealistic to assume that these companies will self-regulate. I mean, history has proven that industries prioritize profit over environmental concerns unless legally bound to act responsibly. And this is proven by the Deepwater Horizon oil spill in 2009 and the Chernobyl disaster. Industries can neglect environmental risk despite their reliance on the resources that they exploit and that they rely on. Moreover, the argument for innovation can be made for other industries, but the issue with space commercialization is that a lack of resources may actually stifle innovation rather than promote it. As space debris continues to accumulate, we are left with less space to send rockets off and more risk in space for satellites and astronauts. We'll end up spending more time trying to fix the issues that we're causing now rather than developing new technology. Thank you.
Thank you. We'll now hear the second rebuttal for the against position. University of Kansas, you have 2 minutes.
First, we'd like to address the issue of it affecting corporations more than states, and that's exactly our issue. Whenever we look at international commercial treaties and international binding law, many of them, if not the majority, are affecting states rather than the private citizens, or they have the option of private citizens to opt out. So we would be binding more of the state action rather than these corporations and these private citizens, which is why the international binding law would not be the best option to support this. If we're looking at history and how this has developed, we could look at the assistance treaties have given less developed countries versus funding. For example, a better solution may be having the World Bank or other international organizations fund these less developed countries and assisting them in reaching space and assisting them in catching up, rather than creating something to limit their capabilities and limit what they're allowed to do. Let's create a law or create a fund where we can help them catch up, and then we can talk about what we should do afterwards. We also want to talk about ensuring fair access. As we've discussed, the fair access is very relative depending on who you're talking about and how we're getting there. If we're looking at the effects that it has, fair access would be found more through funding them rather than limiting them in what they're allowed to do. Private corporations are less affected. For example, if we look at NAFTA or different contract law treaties, the private citizens are fully capable of acting out of them. So when we're considering what we need to be doing, we should be looking at how we can help these countries develop their space works and innovations, rather than how we can limit them and make it more difficult. Thank you.
Thank you. We are now entering the last stage of your debate. We'll hear the concluding statements by the team in favor. Durham University, you have 2 minutes.
Ladies and gentlemen, throughout this debate, we have demonstrated why space commercialization regulations are not only necessary but also entirely enforceable, and I will conclude our main points now. First, the lack of binding regulations will lead to irreversible environmental harm. Space debris is already a critical issue, with over 36,000 pieces of trackable debris posing risk to satellites and future missions. If left unchecked, we face a tragedy of the common scenario where short-term corporate and national interests lead to long-term damage. I have seen similar consequences on Earth: deforestation, climate change, and pollution, all of which worsened in the absence of enforceable laws. We cannot afford to repeat these mistakes in space. Second, international law has successfully regulated global commons before. The United Nations Convention of the Law of the Sea sets binding environmental rules for maritime activities, proving that even vast and hard-to-monitor areas can be regulated effectively. Third, voluntary guidelines and corporate self-regulations are insufficient. The opposition claims that companies and countries will regulate themselves because space debris threatens their own interests, but history has proven otherwise. And technological advancement should be guided and not hindered by responsible regulation. It is argued that regulation will stifle innovation, yet history shows the opposite. And the Clean Air Act of 1970 in the US forced industries to develop cleaner technologies, leading major advancements in emission reduction. If space commercialization is to thrive sustainably, we must set environmental safeguards now before it is too late. In conclusion, without legally binding environmental protection, space commercialization will follow the same destructive path as industries on Earth. International law has the power and precedent to prevent this, ensuring that space remains accessible, safe, and sustainable for future generations. And as we have already said, United Nations Convention on the Law of the Sea directly binds private individuals and corporations engaged in maritime activities. For these reasons, we urge you to support this motion. Thank you.
Thank you. We'll now hear the concluding statements. For the against position, University of Kansas, you have 2 minutes.
We reiterate that international law should not establish legally binding environmental protections to mitigate the long-term consequences of space commercialization. We emphasize that we believe that it will stifle innovation and that we should be focusing on innovating property rights before environmental protections on an internationally binding level. We also note that the treaty covering the law of space claims that states cannot go and claim territories for themselves, and this has been interpreted to mean that this allows for private appropriation. Under this interpretation, 3 countries have enacted national laws recognizing the ability to gain property rights in space. There are also vast amounts of resources available in space for use on Earth. Thus, we should not slow down the progress of our ability to use these to benefit all of mankind. Additionally, less developed countries would be disadvantaged by an internationally binding regulation. Developed countries are already in space, and from this point forward, private companies have been and are the main commercializers. International law will mostly affect states, as most commercial agreements private citizens can't opt out of unless the state itself makes it national law. It is also worth noting that countries with space programs have already started taking responsibility for environmental protections on a state level and therefore do not need internationally binding measures. For example, the US uses the FCC to disposable spacecraft. The ESA has a zero debris approach. JAXA has developed technologies for capturing and removing space debris. And the UK has begun a fund for removing debris removal. Thus, it is not necessary to create an internationally binding treaty that binds the entire planet. Thank you.
Thank you. Thank you for your submission. Thank you to both teams. You can now all relax. You are no longer graded after this part. As the judges will have 2 business days to review your match, to submit their scorecards, for our team then to confirm the scores and send it to you. We now have a possibility to do a short feedback session with everyone on the call today. A short reflection on your research, on your preparation, how it was for you maybe on the topic. So I would like to first pass the floor back to University of Kansas, although your team just was the last to speak for the against position, starting with Ms. Taylor. How was the debate for you? How was the topic, and perhaps how was the preparation?
For me, I thought it was an interesting topic. For preparation, we were discussing it's very difficult when you agree with one side specifically, especially when you're bringing up the space debris, looking at like the danger it poses to astronauts and to other countries when launching it into there. And so finding these arguments on the against side saying, no, trash all that. We believe it's true, but we're going to try to find a way to make it so it's not true, can be a very interesting point, and it's a very good experience being able to find arguments for both sides of something. The experience for it, I've enjoyed these debates so far. This one was no exception. I think it's a very interesting forum, and it's a very exciting opportunity.
Thank you for sharing. For Durham University, Mr. Sluchenkov, the same question to you. How was the experience, the debate, and the preparation, perhaps?
Yeah, I really like this debate. A lot of interesting arguments was brought up, and yeah, for the preparation, it was really helpful that we had a similar motion for the first round. So yeah, we could base our arguments on the first experience. Let's say that. So yeah, that was really helpful.
All right. For University of Kansas, Mr. Poland, how did your team perhaps approach the preparation for the 2 sides of the argument that you had to utilize? Did you find a kind of, let's say, a rhythm for your preparation with your team?
Well, kind of. We sort of just all were looking at it together, just like not taking any sides, but we had kind of delved out and figured out who was going to take what part. So we all kind of prepared for everything, but then had discussed who was going to do the intro and the rebuttals based on what happened. So once we had that figured out, it was pretty easy to put into execution once the competition started.
Right. Thank you for sharing. Ms. Nelligan for Durham University team. How was the back and forth in your preparation for the 2 sides of argument? And did you hear perhaps some familiar arguments from the opposing team?
Yeah, I think it's a really interesting topic. I haven't really thought about it much prior to this. Like, I didn't know much about space debris and what kind of issue it posed. So that was interesting to think about and to read about. I think we had our points were mostly on the innovation thing and actually on the developing nations aspect of for when we were prepping the other side. So I think that was quite helpful that I was able to sort of preempt what the arguments were going to be, but I was a bit taken. I hadn't really considered the property law aspects of space, so I thought that was a really interesting argument, and I enjoyed hearing it.
Thank you for sharing. Ms. Nelson for University of Kansas team. And the same question to you. Were you surprised perhaps by some of the arguments from your opposition during the debate?
I feel like they had a very similar approach to what we had we gotten the for argument. Especially, which I think it made me, I guess, feel a little better about our research, like, oh, we were on the right track. And so it was good to see that, okay, we did see that. But on the other hand, it's a pretty sticky topic to try and find against arguments for. And so I thought it was pretty interesting. And I think to talk about like our research process, we actually had to go to actual websites that companies were saying, this is why you shouldn't put in all these regulations because, and not, I guess, standard legal research sites. So I don't know. I thought it was pretty interesting. So.
Indeed, it's. I think you've gotten quite a glimpse into what you can expect in your future careers. And when you will be preparing for motions for your clients, should you choose the advocate route. And finally, of course, a little bit of, let's say, perhaps this could be a little short survey from us to you. When you were preparing for the debates, did you catch some of the debates from the previous round of other teams, or perhaps your position already? Or perhaps did you even look up at some of the debates from the past editions? Just in general, first to the Durham University team.
I did watch some debates from previous years, but I didn't watch anything from this year, and I didn't see anything that the University of Kansas said. So this was it was kind of a surprise, but also I think, it was good to not really psych myself out too much about how good you were going to be.
Mr. Sluchenkov?
Yeah, I also watched a couple of debates from previous years. So yeah, just to get familiar with the format, like how long is the rebuttal, how long is the main argument and the conclusion. So for educational purposes, yeah.
Perhaps it can be a bit daunting from other debate styles to suddenly move everything within 2 minutes or 4 minutes for
Yeah,
to
that's
make
true.
your points.
Especially for the conclusion, I think, yeah. I think it deserves 3 minutes at least.
Yeah. So for University of Kansas, the very same question. Did you have a chance to catch some of the previous debates, perhaps even of your opponents today?
So I didn't check out any of our opponents. I echo the same sentiment, and hearing how good the opposing side would definitely psych us out beforehand. We had caught the some of the older debates so that we could familiarize ourselves with the debate style. This was definitely very different from, say, Jessup. Harrison and I just competed in Jessup, and so when you have a much longer moot court style debate, it's a fun challenge to try and condense that into something that is less than half the time total of, say, your moot court argument. And so this was very fun and interesting. So thank you.
Yes, also for your team members? Go ahead.
Yeah, I just thought it was a really interesting. I mean, it just really it goes by so fast with the quick 4 minutes and 2 minutes that you really do just have to, kind of say your main points right away and get to it. And it is interesting to see it after doing oral arguments that are longer, how to just like tailor a quick argument to really get your point across and do it in a quick amount of time. So I think this is good practice for that, definitely.
Also, we had actually watched some of the past debates as well, just still figuring out that format and trying to figure out timing, because it was better in preparation, knowing how much time you're going to have and trying to format, for example, the introduction and the conclusion and those things, trying to practice getting it in that time so that you're not rushed or just reading off. And I enjoyed watching the previous debates just to get an understanding of how people were forming their arguments as well, versus if it was more, and from previous experience, are we focusing more on humanitarian approaches and like or are we focusing more on the law and actual legal structure? So what type of arguments seem to fare better, I thought was very interesting. But yeah, I also didn't watch any of our opponents for the exact same reason as everyone else has said. You don't want to look at it and see that they're very good, and you don't want to look at it and think you could do better. Like either way, I feel like there's no good outcome to watching them beforehand, because to me it would just psych me out in some way.
Well, that's definitely an interesting take. Thank you everyone for sharing, and what a match, like for both teams really to share also this experience on preparations. Speaking of preparations, is there anyone you would like to perhaps give a shout out to, be that a mentor, coach, or your student association that helped you out during the journey for the debates? Perhaps I see already the Kansas University team nodding, so perhaps we can start with you.
Yeah, so first we want to thank our university for even bringing this to our radar. We were able to, the International Law Students Association learned of this just from an email being forwarded to us. And then we also want to thank Alan Colombo, who, while he isn't here arguing with us, he has been an invaluable resource. He's the president of our International Law Students Association, and he has helped us immensely with this process and getting everything organized and helping to find judges and things like that. So we definitely want to shout him out.
Right. What about Durham University team?
Well, I think we also want to shout out ELSA, the European Law Students Association, for bringing this to our attention, and we want to say thank you as well to the opponents for just being here today, and giving a good match. So thank you.
Right. Wonderful. Thank you all for sharing. There will be, of course, opportunity to meet also in person during the final week in The Hague. Of course, all participants are welcome. We are already in the midst of planning some internet visits to the international organizations in The Hague. As you know, it will be taking place on the week of the 9th to 13th of June, shortly before the NATO summit. So there might be some also networking options or some seminars we can maybe organize with collaborations of our partners. In the meanwhile, really do recommend reutilizing for the next debates and future, maybe also for your studies, the OUP law trove that you have received access to. And the access will work for a full year after you have activated it. So that could be quite a useful tool both during competition and for your studies. And perhaps finally, before I pass the floor to my colleague, if you do not travel to The Hague, but you decide to travel to the city of your opposition today, or if your opposition were to travel to your city, what would be the thing to do? What would you show them? Or perhaps what experience would you share with them in your city? Perhaps first to the Durham University.
So I think if you were to come to Durham, we'd probably take you to the cathedral, which is an early medieval cathedral. It's from the 12th century, and it's the earliest piece of Gothic architecture in the country. It was also the tallest freestanding building in Europe for 40 years after it was built. And then I would probably also take you to the castle, which is a Norman castle. So it's about 1,000 years old. So it's an interesting historical site.
Exciting. Mr. Sluchenkov also?
Yeah, I would agree with Elish about cathedral because, I would just add that one of the scenes in one of the Harry Potter movies was filmed there, so just an additional picture of it.
Right. Perhaps already some plan to travel is being formed for the Kansas University team. I saw some exchanges. What about you? Should the Durham students travel to your city? What would you welcome them with, or what would you share with them?
So in Lawrence, Kansas, which is like the biggest college town out here, it is actually March, which means March Madness, which is the biggest college basketball event in the nation. It's massive, is about to happen, and the University of Kansas invented basketball. And so it is one of the better teams in the NCAA. And so I think we'd have to take you to a basketball game. We also have a massive sculpture that outlines the original rules of basketball on campus. And yeah, I guess we'd take you around. Funnily enough, though, I grew up on the East Coast, and I grew up in the New Durham, I guess, and so it's kind of fun to hear about old Durham. So Durham, North Carolina. So yeah.
All right. Well, definitely then I even more so encourage your teams to stay in contact. We have already tagged you during the announcements post on LinkedIn, and of course during the announcement post for the debate itself. So that is one way you can find each other online already, and should you wish to exchange email addresses, do not hesitate to let us know. And on that note, congratulations again from me, and I pass the floor to my colleague.
Yes, so that was a great match, second match for both teams, and of course you are just about to get to the third match very soon with the topic sent in advance, of course, and this time to be a different area of law, again, a bit more on the side of trade law. So you can already think about if you have professors or if you have some, I would say, experts who could help you as well to prepare for the last match. And of course, that last match will be against the last team you did not have match with in the group. So just to remind again, you are in a group where there is as well the University of Botswana and the University of Birmingham. I think, by memory, I think the University of Kansas will have a match against the University of Botswana in the third match. And then there will be a derby, as we say as well in French, so it means two universities from the same country. So University of Birmingham against Durham University in day 3. So that will be the next match for both teams. So many thanks. It was a pleasure to host you and to have you for this second match. And another thing I would like to add is that when you will be watching, I mean, your first match, when you will be later in the competition, you will see as well some improvement in your strategy, in your confidence, in everything, in your research skills and argumentation as well. So actually, step after step, when you look at as well the feedback from the judge, that helps as well to prepare for the next stage in the competition. So it is something we notice because we see all the match as organizers, but yourself, you will notice it at some point as well during the world competition. So in any case, don't hesitate to keep contact as well between the two student associations, I mean ELSA Durham and the KU International Law Society, because yes, maybe you can share some activities and events in the future. And finally, as well for your career, networking is important. You never know if you need a British lawyer or an American lawyer in the future. So we encourage all the teams to connect, especially if they are in the same group during the group phase. So thank you again, that was a pleasure, and wish you a great evening, of course, in UK, and as well a great rest of the day, the afternoon, in the United States. So thank you, Mr. Banova, and we keep in touch. Thank you.
Thank you. Well done, everyone.
Well done, bye-bye.
Thank you.